So this video is going to be pretty concise, but we are going to look back at some conversations that we heard yesterday. Brian Steele has filed a supplement to motion in limine number 49, and this is relating to the PowerPoint sought to be introduced by the state through the testimony of Detective Dennis. So it's really only 2 pages, but they attach the PowerPoint, so that's going to be a good time. But to start, I want to play some relevant clips from yesterday. Now, this segment was about the upcoming witnesses and the evidence that's supposed to be introduced through them.
How about, is this number 26, at least on my list, Tyrone Dennis? Is he just has a lot of different types of evidence listed next to him. What's his, is he law enforcement?
He is.
Okay.
He was one of the lead detectives
Okay.
that investigated that assisted in the investigation regarding Mr. Thomas.
Right.
Later
Yeah.
on.
We've heard about him in our videos we've been listening to. That Dennis. Okay.
Yes.
All right. And then you also have music next to that. Is he going to just testify about certain songs, or what's that going to
He
be?
would intended to play portions,
Okay.
not whole songs.
Okay. And he'll give his gang expertise about what
Yes.
all that stuff means. Has he already testified once? Has he been qualified already? Okay.
Yes.
All right.
So
Yes, sir.
a couple things about the state's proposed evidence about through Mr. Dennis or Investigator Dennis. With the music, I'm interested. Is the state planning on playing videos, audio? How is that? Are they proposing, of course, over our objections? And
Right. And a lot of that's already been ruled on. Let's find out. Did you intend to play video or audio when or whatever, I don't know what his rank is, Dennis is going to be testifying?
So it's audio, and these are the overt acts that we have listed. For instance, Act 78, 60, 74, 95, 97, 103, 125, and 129. So we would be playing the audio portions of the audio.
so strictly audio, no video, no pictures.
No, I can't. I didn't say that. I also said that we would be putting in the described social media post.
Oh, yeah. No, he's not asking about social media. He's asking about when you're going to be playing clips of songs. Is that going to be just audio, or is it going to be video also? Is that the question?
Yes, and if there's video, I mean, we've discussed, from my recollection, and I wasn't the one litigating a lot of the
Right.
free speech, First
Right.
Amendment issues here.
Right.
But if there's video, there's certain things in a video that could be problematic to be introduced in front of a jury as well. That's why I'm inquiring. Are we confining it strictly to the words that are spoken?
No. So when we had, so what I didn't make the distinction on my list of which ones we will be entering the videos of. So I will speak with Mr. Sharp and whomever else wants to
Okay.
be involved in that conversation and identify the videos that we will put in as or
Okay. So this witness is within the first 30. And so by
midnight. You said?
the end of Friday, you need to have details for what specifically, not just music, but, you know,
Video.
a video of whatever the name of this song is, or, you know, a 2-minute clip from this song, and here's the minutes that are included, and audio from whatever other song. Detail it for them so that then they can make detailed objections.
And Your Honor, also just to give the court a heads up, 87 Lima is Operations Planner's PowerPoint. I don't have it in front of me, but I'm very familiar with that PowerPoint. That PowerPoint includes all sorts of conclusory language, all sorts of additional information that is not relevant to this case, all sorts of commentary from written down on the, I believe it was intended to be a PowerPoint to other law enforcement. That's my understanding. I could
Is
be
that
wrong.
PowerPoint that Dennis is?
I believe so. And I understand that the state's intending to call him as an expert, but, hearsay and an expert can't be used as a, mere conduit to get into hearsay and other inadmissible evidence. And there's a lot of, I'm saying I know I have numerous objections. And
All right. Is 87 Lima already in evidence or no?
No, I don't think we've introduced it.
Okay.
Evidence, but they,
Your Honor, when we were served with this, I'll get you the date. I filed a motion challenging the admission, and my memory is Judge Glanville said he's not letting that in and asked the state, and they said they were not using it. Now, if that's wrong, I apologize, but I'm pretty sure that's
Okay.
accurate.
All right. So
Now listen quietly to Love in the background. I'm going to rewind it 10 seconds. Listen very quietly to Love in the background.
I apologize, but I'm pretty sure that's
okay.
accurate.
All right. So
I'll check back into our notes because I don't have memory.
Don't
of that
remember.
particular
Okay.
case.
all right,
But
just
we'll-
check
I'll
on that one.
back.
Thank you. See, this exercise may be boring, but it's helping everybody.
And then after this, they pretty much break for the day, and we're supposed to be back at 8 a.m. on Monday. But there were two other, before we look at this supplement and the PowerPoint attached, we got to look at two other clips from today. Now this is going to be about last minute trying to introduce evidence that you didn't tell the defense you were planning to introduce and just thinking you're just going to get it in, and comments on social posts.
It's not necessarily all in. It is just going to depend upon the reason it's being offered. And just as with whatever the, reasoning for the phone call, and I'm not going to say this as to every little piece of evidence. This just needs to be how y'all operate going forward. At the point in time when you anticipate, oh, I actually am going to use this. I didn't think so before, but now I am, or whatever. You tell them so that they can, so that all of us don't have to be scrambling. Okay.
Okay.
Advance notice to the other side about things that are likely to be evidentiary issues so we can deal with them at an appropriate time and not be sending the jury out every 10 minutes.
And so, Judge, we will definitely abide by that instruction. And I guess we'll ask for more granularity, a little bit more clarification if in the middle of questioning.
Obviously. And I mean, that's why we're kind of going through all of this now, is so that most of it you're already going to know in the middle of questioning. Here's how I can use this. Here's the part that needs to be redacted out, whatever. But, like for one of them, you said, I just really don't anticipate in any way using that. And then if you're like, oh, we're in the middle and we take a break at lunch, you tell them at lunch, at the beginning of the lunch, yeah, I'm going to use this after all. It's just as much heads up, as much advance notice as possible. And given that you are supposed to be providing all of the evidence in detail for, the first 30, and I think you're almost to the point where you're supposed to provide it for the next 30, this shouldn't be an issue. But, okay. Mr. Harvey, you wanted to say something.
Yes, one other point, Judge. With the previous exhibit and this exhibit, we previously had a ruling and discussions about the commentary on these.
Oh, I can't even see that because of what's on my screen. But yeah, I don't think, unless the comments are relevant, let's not have those on there.
So
Now, sometimes the comment might be relevant.
But we don't know who's making the comment. We can't cross-examine the commenter. And we have had Judge Glanville rule that the comments come out previously.
Okay.
Who is this that's commenting 70 likes, one comment,
Okay.
you know, come
All right. So I agree with the prior ruling, and I don't know that this is how you were going
And this is the second part. It flows nicely.
to present it on the stand when you use it. This just may be how you've got it now, but make sure before it shows up on a screen with a jury that whatever limits have been placed on this, you abide by them. I mean, I saw the slide from the opening that had something on it that had been specifically talked about and ruled that you had better not in any way put that before the jury. And lo and behold, it's up there on the screen. Not going to get back into it, but that should not happen again. If you know that comments aren't supposed to be on here, you need to make sure before you throw any slide up. And I'm not saying that this was how you were going to use it. I know you're just giving this to us right now, but just make sure everything is clean to the way that it is supposed to be. Okay.
And to be very specific, so there's no misunderstanding, the comments, what the court has just said about unless there is a relevant portion in the comments, for instance, the witness on the stand comments about something else.
Okay.
And for those instances, I would do as the court has instructed and say, hey, these are social media posts. This one right here, I am going to attempt to keep in, and I'll share it as I'm going to present it. Right now, it doesn't have.
Nope, you're not going to share it as you're going to present it. You're going to share it with each tranche of 30 witnesses, okay? If you know oh, somebody has this incredibly, damaging, I want to use this comment, I'm going to use it with this witness. Tell them as you're going through your tranches of each 30 witnesses.
Okay. Yes.
Okay.
Now they're supposed to be clear. The state is supposed to be clear today with what they plan to introduce when Detective Dennis gets back on the stand. We heard her say, the first clip we were really looking at was her saying, I don't remember if that's the ruling Judge Glanville made previously that said we can't bring this Operation Planters PowerPoint in. And maybe I don't remember saying that I didn't plan to use it. So, Brian Steele, this is why we're getting this supplement today. So let's take a look at it. And so you can see this was filed today, 2:21 p.m. Supplement to motion in limine number 49, and we have a footnote that says, on or about April 17th, like Steele remembered. On or about April 17th, 2024, Mr. Williams filed motion in limine number 49. On April 17th, the now recused Judge Glanville orally granted this motion and excluded the PowerPoint presentation at issue. This supplement to motion in limine number 49 adds paragraph 4, which details the oral granting of said motion. So, we get the usuals in the beginning. We're filing this because the prosecution's seeking to introduce this PowerPoint through Detective Dennis. Mr. Williams is innocent of any and all charges in this indictment. And then Mr. Williams specifically objects to all slides that the prosecution purportedly attempts to introduce into evidence at trial before the petite jury through retired Atlanta Police Department Detective Dennis. So attached here are two narratives that, based upon information and belief, one of which will attempt to be used by Detective Dennis to be introduced at trial. Specifically, Mr. Williams objects to all slides on both of these attachments for the following reasons. 1. Slide 1 is an improper closing argument with YSL versus Inglewood Family Bloods, or IFGANG. That is not appropriate in this trial and has no probative value and is substantially prejudicial. Slide 2 is objectionable for similar reasons as stated in 1, including all of the department seals and the narration on same. In fact, with the introduction of all of those slides, why have a trial with witnesses? 3. All slides contain improper commentary and improper opinion evidence and includes impermissible speculation and also violates the Confrontation Clause and hearsay. 4. Statements that have been suppressed concerning Mr. Diamante Kendrick are mentioned in these exhibits, as well as the search of Mr. Williams' home, which has also been suppressed. Additionally, there is mention of the search on July 15, 2015, of a music studio for which the now recused judge already excluded from evidence. So now we get to that paragraph 4. On April 17th, 2024, during the trial proceedings, the following occurred. So this is what happened where it was denied orally and Love was like, I don't remember. Recused judge. And he's doing the transcript like this. Like, come on. Brian Steele. So the recused judge says, all right, counsels, I have several things I'm going to mark as the court's exhibits in order. One of them is a motion in limine that was filed in regards to some regarding the redaction of out-of-court statements of D'Angelo White and law enforcement officer filed last night at 9:49 p.m. By Mr. Shard on behalf of Mr. Stillwell. I'm also in possession of defendant Williams' motion to adopt and adds to Stillwell's motion in limine filed on 4/17 at 8:39 a.m. I'm also in possession of Mr. Williams' motion in limine number 49, which talks about the PowerPoint slide presentation of some 105 pages. References, it's entitled Operation Planters, like peanut, so nut, and goes through, and has different slides therein. And then it has an ellipses here, and recused judge says, no, we're excluding that. Lawyer Love, Your Honor. Recused judge, and I'm going to exclude the PowerPoint that you all submitted. Lawyer Love, we're not even using it, Your Honor. Recused judge, well, you're not going to wholesale introduce it. Lawyer Love, we had no intention, Your Honor. Let's be really clear. We do not intend to introduce that PowerPoint today. We can see it in action.
Things I'm going to mark as the next court's exhibits in order. One of them is a motion in limine that was filed in regards to some regarding the redaction of out-of-court statements of D'Angelo White and law enforcement officers filed last night at 9:49 p.m. By Mr. Shard on behalf of Mr. Stillwell. I'm also in possession of defendant Williams' motion to adopt and add Stillwell's motion in limine. Filed on 4/17 at 8:39 a.m. I'm also in possession of Mr. Williams' motion limine number 49, which talks about the PowerPoint slide presentation of some 105 pages that references it's entitled Operation Planners and goes through and has different slides that they're in. The focus is on why didn't we file this stuff months ago, and let's wind it out and air it out at that point in time, okay? So I'm gonna ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp? Madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude because I told you that this was going to happen.
We reached out to them.
No. We're excluding that. And I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention. Your Honor,
All right.
let's be real clear. We did not intend to introduce this PowerPoint today. I personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, no, well, Mr. Sharp's got objections to it.
But Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection
No.
at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then. Summon our juries, please. Summon our juries. Have a seat, madam. Have a seat. You better exclude that, and next time, make sure you're prepared. Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
We have talked to them. We have said we don't agree.
then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that.
the information they are seeking.
Oh, it's gonna be inadmissible right now.
I'm saying, Judge, that you said to file a motion. There's nothing in
I'm not gonna have any more discussion about this, madam. I'm not.
Talk to them this morning
I don't.
about that.
Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
Your Honor, so the court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week, a whole week and a half ago, 2 weeks, Your
I'm
Honor.
not- well-
And I have asked, I have said I would like to discuss.
Our jury's coming in, madam. Our jury's coming in. Have a seat.
So before we toggle back over to skim through this PowerPoint, few points of thought. What do you think about seeing that exchange in, looking back as a flashback? This was back in April. What do you think about seeing that exchange? Knowing what we know now, also after just reading Max Shart say, he told us to sit down. Well, technically he said, go back to your seat, ma'am. The jury's coming back in. What do you think about the difference in the demeanor here, where an objection from Shard about admissibility of evidence is being granted? And then 3, really my key question. We heard Judge Glanville note, you won't be able to introduce this wholesale. She just said, before Glanville does this is back in April, she just said in this exchange, we don't plan to introduce it, I don't plan to introduce it. But as soon as he says he's excluding it, ruling it out, can't come in, this is what results. So do you believe she never planned to introduce it? Because if you ask me, that's not really the reaction of someone who didn't want that to come in. And actually, let me note one more thing. So Brian Steele only wanted it played till 13:15. So he wasn't exactly pointing Whitaker in the direction of watching this exchange. But if she lets it autoplay for a few more seconds, she'll find herself to what we just watched. With his timestamp, we would have cut off 5 seconds from here, from the start point.
I'm gonna exclude those 2 sections.
Your Honor, Mr. Atkins,
So there, we would have been done 2 seconds before I just hit pause. So Brian Steele isn't requesting that the judge look at anything further than that. But it's right there, so it's possible Judge Whitaker could keep playing just like we did. And I did it intentionally. And going back over to take a peek at Operation Planters. We're not going to look at the whole thing, but I will link it in the description. But you can see, look, all these badges, we're putting a bunch of credibility in here. It's Operation Planters because the name is, a play on the word. Peanut. And it says YSL/30 Deep v. Inglewood Family Bloods. So it's already positioning it as a rivalry. The second slide shows this and says, in January of 2015, a gang war began between 2 rival gangs, the YSL Young Slime Life/30 Deep versus Inglewood Family Bloods IF Gang. And yeah, we're getting a bunch of pictures of the people that were involved in this gang war. And so some of the pushback is the commentary. So the incident started as rap related, but quickly became gang related. We've got a younger picture of Woody. The beef between Mr. Kenneth Woody Copeland and Mr. Kelvin Shell Kell Watts Curtis is what fueled the ongoing beef. And so again, you can go through all of it. It paints a storyline of sorts with the narrative commentary throughout. Pictures of people that have plea deals or immunity deals. Some information and pictures on Donovan Peanut Thomas. But on a quick scroll, something like this really caught my eye in light of the Bruce Harvey argument. So you've got these social post screenshots, and we have Love and April saying, we don't plan to introduce that. Good, I'm excluding it. Well, what? No, you can't do that. Why would you do that? Well, can you imagine, maybe just trying to throw these things up on the screen? Do you think it's a valid motion in limine and a new supplement relating to that motion in limine? Do you think Love really doesn't plan to just randomly introduce some of this stuff? And so on this one, there's a comment from someone, and I'm not trying to put a specific person on blast, but there's commentary that goes to character evidence of Nut. So, R.I.P. Nut. I remember meeting y'all in Waffle House. Even then, you was a sweetheart. It's sad someone had to do you like that, but rest easy, baby. So just these little things in here, these are the types of things that the defense is objecting to. We saw Bruce Harvey object to it for something not part of this PowerPoint. And Steele, and I believe Shart, and really everyone in that room, all the co-defendants, their counsel, are happy to reiterate and revive this motion in limine, and also remind Judge Whitaker that there's been a previous ruling by Judge Glanville to keep it out. So when Detective Dennis gets back on the stand and Love is still struggling to alert the defense, that's their homework for today. She's supposed to tell the defense, great, we finally said we're going to call Detective Dennis as part of our next line of witnesses that are coming in, and we have homework. We're supposed to tell you what evidence we plan to introduce through Detective Dennis. And we still hadn't done that. We didn't do it last week. We didn't do it this week. So today is our last chance. And back in April, this PowerPoint that would be introduced through Detective Dennis, Love seemed to flip her lid when Judge Glanville said it's excluded. Then she says, yesterday, in court, yesterday to Judge Whitaker, I don't remember that. I'll have to check. So Brian Steele did the checking for her. This is where we're at. So this will be in the description for you guys to look through. But what do you think? Do you think Love is going to want to suddenly disregard Judge Glanville's previous rulings? Ask Whitaker to rule differently than how Judge Glanville ruled? Do you think she'll get her homework done today? Well, do you think the state will get their homework done today? Do you think they'll try to introduce this or something, anything from this PowerPoint wholesale and say, well, we didn't plan to introduce it, but it's suddenly relevant. That's why we didn't tell the defense we planned to introduce it. So forgive us, Judge. What do you think? What do you think? And honestly, when is enough enough? So happy Friday again. You guys all have a good weekend. See you soon.